Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am pleased to have one of my 2025 legal interns, Lauryn Bishoff. Thank you for being here, and thank you for being part of the summer program. It's been great, I think.
I think so too. Thanks for having me.
Super. Today, we are going to discuss the impacts of or myths in intellectual property, something along those lines.
Yeah, the topic is debunking intellectual property myths.
Right, I couldn't remember the word
Yeah.
debunk. Why don't, and today, or yes, you're going to be interviewing me.
hmm
So let's have at it.
Perfect. I got a couple questions. So to start out, the first myth I'd like you to debunk is a trademark has to be registered to have any type of protection.
The answer is no. There's three different types of trademark protection. One is common law rights, one is state law rights, and one is the federal registration. Once you start using the mark, you get common law rights right away, and they are enforceable. Therefore, it's not mandatory, but the best protection is federal protection, where you get the federal registration. You can put the little R next to your mark.
Okay. Where exactly are the common rights enforceable?
Any
Anywhere?
state, yeah, anywhere
Okay.
in the United States, I should say.
Gotcha. Okay. The next one is everything on the internet is free to use.
That would be great. Unfortunately, that's not the case. You just can't take copyrighted material and use it however you want. And you take music, for instance, you just can't take someone's song and use it in a video of yours and then try to sell it or commercialize it in any way. Uh, the news you can use for your own personal information, but you can't just copyright, or I shouldn't say that. You can't just take it and use it and then disseminate it as if it's your own. So the answer is no, you can't just steal someone's software and use it however you want.
Yeah. Follow-up question then, what if you give them credit?
Credit is not enough. It would be
No.
nice just to say, oh, that song was by the Beatles. And by the way, I'm using it to sell uh, my products or whatever the case may be, or to say, oh, I've got a Hershey's bar, and but I'm going to use it and sell it as my own. And you know, just the credit is not going to help you pretty much at all.
Gotcha. All right. The next one is a patent gives me the right to use my invention.
That's a common misconception
Yeah,
that you had. The
I did.
right, the a patent is a negative right. It's a negative right to exclude others from using your patent. It does not give you the right necessarily to use your own technology that you have patented. You could still be infringing someone else's patent, and therefore, you infringement and patentability are two separate concepts. Sometimes if you're infringing someone else's patent and yours is a nice improvement, you can talk to that patent holder, maybe cross-license, and you can both take advantage, or the original patent holder can accept royalties for using their patent. I use as a very simple example, a pencil which has graphite in it. The first person can get a patent uh, on that, and then you develop the eraser and put that at the end. You are still infringing the person's patent with the pencil and with the graphite in the middle. Uh, but the other guy, uh, woman, can't use the pencil with the graphite and the eraser.
Yeah, very good example. The next one is patent protection is too expensive and complicated for my business.
That is, I'd say, a misconception. Uh, Patents do have costs associated with them. They're more expensive to get than trademarks or copyrights, but patents can be indispensable for many reasons. One is to license or to sell your technology. Another is it's difficult to uh, sell your company if you want without any intellectual property, without patents, because a third party is going to say, well, what am I really going to get? Someone could easily copy uh, that. Sometimes a patent and a patent portfolio are used for defensive purposes so that someone else will think twice about suing you because you can possibly assert your patent against them. And therefore, it has many different purposes, not just something to put on your wall. Some people just want it to put on your wall, but that's not the most effective way. So the expense, while it may be seemingly expensive, can be invaluable, especially if you're the small company and you don't have a market share, you don't have the ability to market your product, and the big company is trying to basically steal your technology.
Yeah, my next one was gonna be my business is too small for patent protection. So you pretty much answer that.
Well, but just and then you think, well, how can I afford litigation?
Hmm.
But there are options for that. There's companies that will fund the litigation. There's law firms that will possibly take the case on contingency fee basis. And so it's not necessarily that you have to bear all the costs. Of course, you're going to have to pay people to either fund it, or you're going to have to pay the attorney a percentage of whatever they get. But if you can't afford the litigation in the first place, then those are very good options.
Yeah. All right. My last one is gonna be ideas can be protected under intellectual property law.
The ideas cannot be protected. With copyright, I can have the most incredible idea for a painting, or I've got an idea for music, but with copyright, you only have something that's fixed in or on a tangible medium. And therefore, until you get it, until you actually have the expression of that idea, you do not have a copyright. For trademarks, I can have an idea to open up a fast food restaurant and call it McJoe's, or you can call it, Bishoff's Diner. Uh, Trademark law, it's based on actual use. And then for patents, you have to have a conception, which is basically the idea, but you also have to have it a reduction to practice. And what I use as an example is I've got a great idea of having a carpet that can take me to India in 1 second. And so I think it's a great idea, be inexpensive, very quick. Unfortunately, I don't know how to make it, and I can't reduce it to practice, and therefore it is not the subject to get a patent. So I hear commonly someone stole my idea,
Hmm.
and you can't pursue that unless you go through one of the uh, common types of intellectual property, copyrights, trademarks, and patents.
Right. Perfect. Well, that's all the myths I got for you today.
Okay, I'm sure there's other myths to be debunked, but we'll save it
For
for
sure.
another episode. Thank you for the interview.
Thank
I think you're doing a great job, both in the interview and uh, in the internship. Keep up the good work. And for everyone else, until next time, tune in next time for Unraveling Intellectual Property with Michael Stein. Take care, everyone.
you.